This is the title, Managing the Right of Access to Water in South Africa, Facing the Challenges. And the primary focus will be on how these challenges can be faced using the law. But as you'll see in the conclusion, we need more than the law in order to address these. So the structure of the address will be as appears there on the slide. So I'll look at the context, so kind of the factual situation relating to water, availability of water, access to water in the country, then focusing the particular address tonight on access to water services, and I'll explain what that means when we get there. Looking at the legal framework, touching briefly on new norms and standards relating to provision of water services that have been promulgated in the last month or so, and then looking at the host of challenges that face the relevant authorities in providing access to water in the country, and then drawing some fairly general conclusions. So if we look at the context, these are I've broken up an infographic that I took from a WWF publication that came out earlier this year, looking at the future of water in the country. And what all of these particular graphics and information show is that South Africa overall is a water scarce country. So our average annual rainfall is 490 millimeters, which is kind of what Scotland gets in one day, I think. And the world's average annual rainfall is 814, so we're quite substantially below that. I think we're something like the 30th driest country in the world, although there is a difference in rainfall patterns in different parts of the country. So the west is generally more dry than the east, which is where I come from. So we get more rain than most of the rest of the country. Most of our water that's available has already been allocated, and what this graphic shows is that there's about 2% that hasn't been allocated. Now, that amount that has been allocated includes the amount that is allocated to the bodies that provide water to people like you and me. So it's not just industry and agriculture and so on. So the municipalities, which are the primary players in this area, they would be part of the users that are getting the 98% of water that's already been allocated. As you can see there, though, there's a considerable amount of water that is being wasted through primarily leakages, which isn't just a South African problem, but I think our percentage is higher than global norms in respect of wasted water. So just to explain what I'm talking about here in respect of water services, generally the policies and the Department of Water and Sanitation in the country distinguishes between access to water services, which is what I'm going to be focusing on tonight, and access to water resources. So when we're talking about water services, that includes provision of water as well as sanitation to consumers who are not irrigating with that or using it for industry. So people who live in the country who turn on their taps, if they have them, as you'll see, they don't all have them, in order to provide for water for drinking, washing, cooking, sanitation, and so on. So what I'm going to be focusing on tonight is the access to water services issue, and not access to water resources. There's a whole lot that can be said about access to water resources as well, but that's not the primary focus of the right to water, which is underpinning the talk tonight. So as far as the law is concerned, the primary legal norm that we are concerned with here is in our constitution. And there's not a lot of countries in the world that have explicit rights to water. We are one of them that does have that. So in section 27, the constitution refers to everyone having the right to have access to sufficient food and water. It's part of a right that deals with a number of socio-economic rights. And that is qualified by subsection 2 that refers to the state having to take reasonable legislative and other measures within its available resources to achieve the progressive realization of the rights in section 27. So what this means is that a citizen can't simply turn around, click his fingers or her fingers and say, where's my water? The state is required to realize this right progressively So it recognizes the fact that when it comes to socio-economic rights, the state actually has to provide resources and use those resources in order to make that right available. So it can't be done overnight. So how does this progressive realization work? Well, probably the leading South African case dealing with socio-economic rights is the Grootboom case. I can give you full references later. I'll have to look them up, they're not in my head. This was a constitutional court decision, fairly easy to Google, I would imagine. This didn't deal with water, but dealt with housing. And one of the issues that the Constitutional Court was facing was whether, when it came to socio-economic rights, that there would be a minimum core that the law would require. And in Grootboom, the court was reluctant to do that. So what the Constitutional Court said is, we're not going to dictate a particular minimum core of the right to housing. What we are going to say is that what is provided by the state must be reasonable. And that ties in with this notion of progressive realization. So what is reasonable will depend on the available resources, and what it requires is for the state to, first of all, have a plan as to how to provide for that particular right, and secondly, to actually do something in relation to that plan. So it's not enough for the state to say, we have a plan to provide housing, or we have a plan to provide water, and then not actually do anything. There has to be measurable steps to achieving that goal, the goals that are set out in that plan. So in Grootboom, the court made that decision in relation to housing, and that generally has been the standard that has been used for socio-economic rights across the board in the country. The Mazibuko case was a case that got to the Constitutional Court dealing specifically with the right of access to water. This was not, however, a progressive realization case, and I'll explain this in a bit more detail shortly. The reason being that in Mazibuko, the people who were applying to court already had access to water. And what they were complaining about was various initiatives by the state that limited the access that they had previously. So Grootboom was a case of people not having housing at all and asking the courts to come to their assistance. In Mazibuko, the people already had water, so it wasn't a case of asking about progressive realization. One of the things that the applicants were asking for in Mazibuko was for the court to provide a minimum core, so what I was talking about earlier. And in the first court, the lowest court where the matter rose, the court decided that the minimum amount of water that would meet the right of access to water in section 27 would be 50 litres per day, which they based on various scientific studies that have suggested that 50 litres per day is sufficient to meet a basic right of access to water. That matter went then to the Supreme Court of Appeal, which in South Africa is not the Supreme Court of Appeal because you still have the Constitutional Court above it. So basically the appeal court, and the Supreme Court of Appeal played around with those figures a bit and decided that a minimum core was 42 litres, not 50 litres. This is significant because what the law has required, and you'll see this later in a particular provision, is 25 litres per person per day. I'll talk a bit more about that later on and exactly what that means for how much water one has in domestic settings. And then when it went to the Constitutional Court, the court said, no, we're not prepared to put a figure on this. You're prepared to accept that the government's commitment to 25 litres per person per day is acceptable, but we're not prepared to put a minimum core on what the right of access to water is. So they followed the position in Grootboom. But there are a number of criticisms that can be leveled against the Mazibuko case, one of which is that it wasn't dealing with a progressive realization case. It was dealing with a situation where the applicants already did have access to water, and that was then curtailed by actions of the state. And we can talk a bit more about that case later if you'd like to ask questions on it. I have to go through this fairly quickly. Now, when it comes to provision of water services, what all of this legal language here says essentially is that it is local government that is responsible for providing access to water services. So it's local government that first of all has to roll out water to those people who don't have access to water already, and secondly to ensure that once that's been done, that access to water will be maintained. And that's an issue that we'll see as a problem later on. So as far as access to water services is concerned, in 1994, which is kind of a ground zero as far as South African law is concerned, because 1994 was when we moved from the apartheid legislative regime to the post-apartheid new constitutional era. So in 1994, about 45% of the population, so that's the figure here is households, 45% of households did not have this RDP here, refers to the Reconstruction and Development Program of the ANC, and essentially what it means for these purposes is that the RDP standard was met if there was a basic water supply, it's 25 litres per person per day, within 200 meters from a person's dwelling. So in 1994, 45% of households didn't have that, and you'll see how that's improved over the years, so that in 2014, 14.1% of households don't have access to basic water supply. That's still a substantial number of people, 14% of something like 54 million. I guess 14% of households as opposed to persons, but it would work out more or less the same. But those figures don't reveal some nuances that could make it worse. So the position in 2014, that last figure in the table beforehand, was that something like 86% of households had water within 200 meters of their dwelling. If the standard were to be changed, and this is what our National Development Plan is asking for, to a yard or house connection, so instead of 200 meters away, if your water is to be piped to the edge of your yard, it's then you're responsible then to get it from the edge of your yard into your house, that would reduce to approximately 75%. So the current figures now are that 48% of households have water in their houses and 27% in their yard. Okay, the other 15% don't have that. That 85.9%, so it would be about 10-11% that would have water within 200 meters. If we take into account reliability, in other words, they have the supply of water on a reasonably permanent time frame. So it's not a case of sometimes you switch the tap on and there's water that meets the required standards, but often there isn't. Sometimes reliability is a big problem, and if we take into account a reliable water supply, then that reduces to about 66%. And if we take these two together, the 75% and 66%, it could be that only about 55% of households are getting reliable water supply within their house or their yard. So there's still quite far to go in respect of making sure that everybody has access to water services in the country. So as far as the law is concerned, when we're dealing with the backlog, and what the backlog refers to is those people who don't already have access to water. So that's the 14.1%. The law requires progressive realization of the Section 27 right. So there has to be a plan in place as to how these people are going to be connected up to the water services systems. Where access has already been provided though, and where people are, for whatever reason, losing access to water, either pretty much permanently or certainly intermittently, then the internal modifier, that is that progressive realization modifier in Section 27.2, is not applicable. Progressive realisation doesn't apply in a situation where a person already has had that right. So what the law provides then is that where there's any kind of interruption or withdrawal of the water supply, it would be regarded as a limitation of the Section 27 right. Our Constitution provides for limitations of basic human rights, but essentially those limitations have to be justifiable. And what we see in the South African context is often the limitations that are happening in respect of already existing access can't be regarded as justifiable. They wouldn't meet the requirements of the limitations clause in the Constitution. So in addition to the constitutional aspect, if we look at the legal framework, the legislation which is primarily relevant in this regard is the Water Services Act of 1997. And two definitions which are important for current purposes for this particular lecture. Water Services Authority is basically a municipality, local government. A water services provider is a person who provides water services to consumers or to another water services institution. Now, in most cases, the water services provider is also the Water Services Authority. In other words, the water services provider is a local government body, a municipality. But what this provides for is the possibility that some other entity could be providing water. And we have had some instances where private corporations have come in to provide these services, but I think for the most part those have fallen out of the picture because they've realized that there's not enough money to be made in providing water to consumers in South Africa. So pretty much all of the time the water services provider is also the municipality. Section 3 in the Water Services Act really echoes what the Constitution says. Everyone has the right of access to basic water supply and basic sanitation, reasonable measures to realize these rights, and that there can possibly be limitations to those rights as provided for in the Act. Section 9 provides for the Minister to prescribe compulsory standards, and I'll be talking about these standards that are really hot off the press in a few minutes' time. So the standards can relate to any of these things, including the provision of water services, and importantly, subsection 4, every water services institution must comply with the standards that are set down in terms of this section. So the standards are subordinate, delegated legislation, but they are binding on any water services body that's involved in the water services sector. Regulations under the Water Services Act in 2001 set down this minimum standard of 25 litres per person per day. That's where it comes from. So it talks about 6 kilolitres per household per month, and if you do the arithmetic, you'll figure out that that is envisaging a household size of 8 people, which in many cases is obviously larger than what the household is. But if you are part of a household of 8 people, 25 litres per person per day, and you think about what that actually means, I think flushing a toilet is something between 10 and 15 litres. So if you have 25 litres per person per day, it's not very much water. It's also a problem, of course, if your household is more than 8 people, and that doesn't necessarily mean more than 8 people in one family. Because remember, we're talking about the amount of water that is piped to a particular yard. And in the Mazabuko case, for example, evidence showed that in many of the plots in this particular area, which is part of Soweto, just outside Johannesburg, there was more than one family or more than one household living on a single plot. So often there were up to 20 people living on a single plot getting 6 kilolitres per month. So obviously that reduces that 25 litres per person per day quite substantially. And then there's various other requirements in terms of pressure and so on that also have to be met. So the new norms and standards, I'm not going to go through these in any detail, but what you'll see is that the Department of Water and Sanitation, which is the National Water Department, has set these standards to be fairly flexible in terms of the type of access that different people might really qualify for, ranging from the basic to the full service. And a lot of that obviously depends on what resources are available in terms of infrastructure and amount of water, and secondly, what consumers are able to pay. So as you can see, these are fairly new, just over a month old, and as I said, without going into all the detail, essentially what the standards do is that they envisage these different levels. So you've got a minimum level of service, and you move up the ladder through a middle level of service to full level of service. And the bottom line for basic water is 25 litres per person per day, as I've just been saying. The norms and standards provide for what has to be in place in respect to these different levels of service, and they also deal with the issue of interruptions, which is a major problem in many parts of the country. People have access to water, but the water isn't available for often more than several days, and people understandably are getting rather upset about all of these interruptions. So on that particular point, the standards have dealt with what an interim level of service will be, and they refer to this as, first of all, being an interim measure, so it can't be something that happens again and again, and that where there is an interruption, that people should have access to basic water of an adequate quality within reasonable walking distance, while repairs to the water services are in effect. In addition, what the norms and standards say is that the Water Services Authority in question shall commit to rectifying the disruption within 48 hours. And there are many people that have had their water interrupted that would have loved to have their water put back on within 48 hours. People sitting without water for a week or more often. And that a disruption or breakdown shall not last longer than 7 days, which again, in many cases, is not the position at the moment. So these are new standards that have just been introduced in September, but these are standards that, according to the law, water services bodies have to comply with. So what are the challenges? So I'm going to go through these one at a time, and this isn't necessarily a comprehensive list. I could probably think of more. These are the main ones. Lack of resources, shortage of water, and I'm talking about the general shortage of water that there is in the country, without taking into account the effects of drought. Obviously, the situation is exacerbated when there is a drought, which is what we're suffering in many parts of the country at the moment. Sewage pollution of water. Polluted water due to acid mine drainage. And then the issue of informal settlements. So let's look at these one by one. So what are the lack of resources? Remember, I said that it's local government that is responsible for providing water services. And many local government bodies just don't have capacity to govern water, let alone many of the other things that have to be governed in a municipality. So many of our local government bodies, particularly the ones in the smaller sort of semi-rural municipalities, there are severe constraints in terms of the ability to be able to govern a municipality. Basically incompetence. And there's a whole lot of reasons for that, which we can't get into now. A number of infrastructural shortcomings. So often the problem is that a particular municipality is trying its best to deal with the water services issues, both provision of water and dealing with sanitation issues. But the infrastructure that it has available was built for a size of population considerably less than the current size of population. So often you'll have a situation where maybe the whole water reticulation system is designed for a population of 50,000 people, and there are now 100,000 people that are supposed to be serviced by that system. And as you can imagine, that's just not going to work. Now, how do we deal with this? We constantly say there's a law that you have to comply with, because where there are these infrastructural shortcomings, the infrastructure is just not going to allow the law to be applied properly. So what we need is a huge amount of money. And it's been estimated that the amount of money that's required to deal with these infrastructural shortcomings, both in respect of provision of drinking water, as well as dealing with wastewater, so water treatment works and so on, is something in the region of 67 billion rand, which is about 4 billion pounds. And most municipalities just don't have enough money in order to deal with these infrastructural shortcomings. So unless there's a plan that's made at national level to address this shortage of finance, a lot of these infrastructural shortcomings aren't going to be addressed by the municipalities. So the source of municipalities' money is local property taxes, and there's a lot more of those in the more urban municipalities, obviously the municipalities with more industry and commerce and so on. And secondly, there's grants from national government. But those grants from national government are not focused only on water, they're on socio-economic services generally. So the amount that's earmarked for water is quite small in comparison with that 70-odd billion that's required. And there doesn't seem to be adequate monitoring of how that money is spent either. So what one finds is that often maintenance funds for, say, water treatment works are treated as kind of slush funds for if other amounts of money fall short. And there's often severe problems in respect to skills. So the sorts of people that can manage these plants properly, water engineers and so on. So, you know, if one looks at all of those, other than the governance capacity, a lot of it boils down to this. And without that, the law is really going to be almost impossible to comply with. Water shortages, well, one of the things that the department has agreed is critical in respect of addressing water shortages, and these are the general water shortages, I'll get on to drought in a minute, is to reduce that wastage that I spoke about earlier, something like 37%. And often one of the main reasons for that wastage is the infrastructural shortcomings that I was talking about earlier. So you've got systems of pipes, where those pipes were put in 60, 70 years ago. They're made out of clay and they keep on breaking. So certainly in my municipality, we'll often have a water interruption for a few hours because there's a burst pipe. And what happens is that the guys come along and they put in PVC, basically a band-aid. So they put in a length of PVC pipe where that clay pipe is broken, and then a few months later the clay pipe further on down the line breaks again. They bring in another bit of PVC instead of changing the whole system, which, remember, costs money. So if we can get that right, that will lead to considerable savings of both money and water. But it costs a fair amount in order to do that properly. Various alternative sources have been mooted. Rainwater harvesting, a lot of people are doing that anyway, particularly for water used in refilling swimming pools and gardening and so on. Some of the cities, particularly the bigger ones along the coast, have started talking about desalinization, and some of them have spoken about recycling water. And I just want to digress for a moment. It works, and it's entering the Umsunduzi River here, which is the river that joins up with the Umgeni that goes down to Durban. If you look at that map a bit more closely, so there's that thing that kind of looks like a bit of a dragon. That's called the Ananda Dam, which is fed by the Umgeni River, which contains purified effluent from Pietermaritzburg. And the Ananda Dam's purpose is a reservoir for provision of drinking water to Durban. So all of the people who are complaining about the idea of recycling water in Durban are really drinking recycled water, but it's from Pietermaritzburg, not from Durban itself. So somehow people have to get around this mindset about recycling water if we are to deal with some of these shortages that we have. So what exacerbates the usual shortages is when we have a drought. And these 2017 norms and standards have specifically said that where we have drought situations, which can usually be foreseen relatively well, that's not regarded as an emergency. So there's provisions in the norms and standards for emergency water supply, as well as interim water supply that I spoke about earlier. So the emergency water services provisions wouldn't apply in drought conditions, basically because the Water Services Authority ought to have foreseen that there would be a problem and to put steps in place to ensure that there isn't an emergency situation at the end. So there's serious drought conditions at the moment in the Western Cape. The Western Cape is on its last legs. That includes Cape Town, as far as water is concerned. And they're entering their dry season now. It will only start raining again in South African winter, which is your summer. So it's just not looking very good for a city of several million people where there just isn't enough water. Many other areas in the country, particularly in the central parts of the country, are recovering. There's several municipalities that literally ran out of water. It didn't have any water to supply to people in their areas of jurisdiction. So people had to rely on surrounding farmers who had borehole water, or they had to rely on tankers that picked up water somewhere else and then provided water for people who lived in those places. So one of the big problems that would obviously impact on water services, because it makes purification of water more expensive, and sometimes the purification plants that are available are not adequately able to deal with the extent of pollution of the water coming in. The Department of Water and Sanitation produces periodic green drop reports. The latest one that is kind of available is 2013. Now I say kind of available because there's really just an executive summary. The first one came out in 2009, and there was a huge amount of detail in there about which individual water treatment work wasn't complying with various standards. Now that information is now kept away from the public, so we can't access that on the internet. All we can access on the internet is the general trends. And it's probably because it's quite embarrassing if one looks at how water is being purified throughout the country. So there are 824 wastewater treatment plants in the country and 152 municipalities. Remember, Water Services Authority is a municipality. I'll just give you the overall trends here. So this is a pie chart seeing how these water treatment plants are performing. And the yellow and red are those that are scoring less than 50%. So there's a variety of indicators that are used to generate the score. One of them being whether they're actually treating the effluent that's coming through that water treatment plant to the standard that's required by the law. And you can pretty much bet that none of those water treatment plants in the red and yellow categories are complying with those effluent standards. A number of these aren't complying either, but they're doing better in respect to some of the other indicators that are being used. So it's just under 50% of that 824 water treatment plants that are scoring less than 50%. So in other words, if you think of that in kind of factual, in a factual sense, that means there's something like 400 plus water treatment works that are releasing sewage into rivers. Okay, so that picture I showed you earlier of the stuff coming out of the Pietermaritzburg water treatment works, that was purified, I think, anyway. But in many cases, what's coming out of the water treatment works isn't, because of sorts of issues that I was talking about earlier. Infrastructure is not big enough. Keeps on getting flooded with storm water. So when you have a big storm, all of the sewage just goes straight through. It doesn't get purified at all. Lack of maintenance, lack of proper supervision, and so on. So that's a huge problem. So how do we deal with that? Well, the Constitution says that the provincial government must provide monitoring and support of local government in its province. So all of that sewage that's going into rivers, it's not private bodies that are not complying with the law. It's local government that's not complying with the law. So usually when we think about compliance and enforcement in relation to law, we're thinking about private bodies or corporations. And perhaps the thinking there would be, well, if their infrastructure can't allow them to comply with the law, then they must just close down, they must stop operating. But municipalities can't stop operating. Municipalities are there. They can't say, well, we're going insolvent and we're not going to do this anymore. They have various responsibilities in terms of the Constitution. But there's little, if any, supervision by provincial government, let alone national government, which ultimately is responsible for water and sanitation issues. If local government messes up in respect of other issues, often provincial government will step in. It's referred to as being placed under administration. So often when the finances are not as they should be, provincial government places a local government under administration, sorts out the financial issues, and then hands it back over again. There hasn't been any of that in respect of these shortcomings in respect of water. And I think part of the reason is that provincial government in South Africa has no constitutional or legislative competence in respect of water. It's national, the National Department of Water and Sanitation, and local government. And the National Department of Water and Sanitation seems to be content in producing these reports, so it can name and shame the local authorities that are not doing their jobs, except they're not naming and shaming them because they're not giving us the details anymore. So there's little, if anything, being done by national government to ensure that local government is doing what it ought to in respect of purifying effluent. So what are the causes? Well, the infrastructure is not good enough. Often the staff that are operating the water treatment works are improperly trained. They haven't got the right qualifications. Often the problem arises not after the water treatment works, but before the sewage even gets to the water treatment works. So in the same way that our water pipes are bursting, sewage pipes are also bursting. Okay, sewage is highly acidic, so it corrodes sewage pipes. Often the problems are, we have a huge problem in South Africa with people stealing metal, whatever kind of metal that they then sell to scrap metal merchants. So they steal copper wires off telephone poles. They steal, if you have a sign outside your house made of metal, that'll get stolen. So people are stealing the metal bits off sewage pumps. So what happens is that that pump then breaks down and the sewage doesn't get pumped from point A to point B. Often people who have flush toilet systems are flushing things down that shouldn't be flushed down toilets, with the result that there's a huge blockage and then the system bursts. And there are problems in respect of the infrastructure, as I was talking about earlier. So there's a whole range of issues here. So it's not simply a case of local government saying, well, we're just ignoring the law. We decide we're not really going to deal with this water treatment issue, but other things to do. Certainly prioritization is a problem, but much of the underlying issue here is lack of resources. There's not enough money to deal with these issues. It goes back to that 67 billion that I was talking about earlier. Another pollution issue, acid mine drainage. So this is more localized from mining areas. So what happens here is that highly acidic water is decanting from disused mining operations, and perhaps not only disused mining operations, other mining aspects. And the problem with drinking water becoming, or potential drinking water becoming contaminated with acid mine drainage, is that the treatment plants that municipalities use to treat water to bring it to potable standard, those focus primarily on getting rid of the bacteriological sorts of impurities, not acid mine drainage. Okay, so chlorinization, for example, will deal with all the microbes and so on, but it's not going to help when your water is acidic and full of all kinds of metals that the acids have picked up. A good example of this was a fairly small town in Mpumalanga province, not all that far away from the Kruger National Park. So this is the town at the top of that map, Carolina, and this is the source of the town's water, the Bushmanspreek Dam. And there was a huge storm in the beginning of 2012, and that storm resulted in a huge amount of acidic runoff, acid mine drainage, ending up in the dam, with the result that the entire water supply for the town was now contaminated with acidic water containing metals, and heavy metals at that. As I said, the purification system wasn't able to deal with this type of contamination, and it was several months before Carolina managed to sort its water supply out. Eventually what happened is that some water was taken from other dams down here to flush this one out, and the acid mine drainage then went further downstream, but the quality of that particular dam was somewhat restored in order to be able to address the water access issues. Now the problem there is that that's something that's completely out of the municipality's hands. There's nothing that they can do to prevent that situation arising, and there's nothing that they can do to purify that water. So that's an issue of national action. The Department of Water and Sanitation had to address that particular issue. But it's also an issue about rampant mining, particularly coal mining in many parts of the country, that have huge negative environmental impacts. Informal settlements, there's no particular issues here to put on the slide, but obviously the issue with providing water for households is that the challenges of providing water for households that are properly mapped out and on a town planning grid are difficult enough. Informal settlements add a whole different layer of difficulty, because these settlements, as the name suggests, are informal. They're often shacks that have no plumbing whatsoever, that are often placed in areas where there hasn't been any housing development because it's inappropriate, for example in floodplains and so on. So it's really difficult for authorities to be able to get water into those areas. So those are the sorts of areas where it's probably only realistic to think of access at basic levels, because the reticulation systems to get into informal settlements, particularly if the authorities are thinking of moving people out of informal settlements to put them into more formal housing, one wouldn't want to look at kind of permanent water reticulation systems to areas that are not going to be there forever. But there's huge problems obviously in respect of both access to water and access to sanitation in informal settlements. There's large levels of urbanization happening in South Africa, as is the case in most of the developing world, which exacerbates this problem. So the conclusion, or conclusions really, you can see that there's quite a substantial legal framework in place to address issues relating to access to water services in the country. The problem, though, is that that law can really only operate when there's certain factual circumstances in place, such as adequate resources. So what's going to happen is that this law, or these laws, are not going to be complied with as long as there are these infrastructural deficiencies, as long as there are the resource constraints that can only be addressed by provision of finance. That requires basically government at cabinet level to prioritize water as something that requires expenditure of that amount of money in order to ensure that the law can actually do what it is intended to do. Thank you. So I'll answer any questions that you might have arising out of that.
Thank you.